So a big welcome to this session on GDPR with the amazing Robyn Banks. And most of us here are UK based, but Roberta's just joined us from Italy, which is lovely. And I met Robyn probably 20 years ago, I should think, from some networking events that we both used to go to. We both had businesses for a very long time. And Robyn helped me with my data protection when I was a full-time holistic therapist. So I was treating 25 patients a week. I was having sensitive information that I was writing down all by hand in those days. And Robyn kind of signed me up to the ICO. And then when GDPR came in, she said, she just naturally flowed into that. And because Robyn has always worked in data for a long time, she has this incredible ability to just cut through the stuff that I since realised often came from solicitors who had this lovely ability to make things very, very complicated. And people were scared, really scared of doing things wrong. And Robyn just kind of comes in and says, oh, just do this, this and this and that. You don't need to do that. So that's why we got her here today. So a big welcome to Robyn. Over to you.
Thank you very much indeed, Rosemary. Yes, has it really been that long? Oh my God. Yeah, it's also frightening when you realise I've actually been running my own business in this stuff for 20 years now, and 25 years working in the field, and was working in central government before that. Yeah, Roberta, everything I say, virtually everything I say today will apply to you too in Italy, where you may collect data and process data. You have your own version of the GDPR. Which you may apply to. I will tell you if there is one bit that is UK only, and I'll let you know which bit that is. All right, but otherwise everything I talk about concept wise, etc., applies to you too. So how did this all come about? Well, in 1984 we had the Data Protection Act originally, and that only at that time applied to electronically held data. Then they realised that a lot of data was being held on paper, and like Rosemary was talking about, with notes and things. So they then had the 1998 Data Protection Act, and that was to include paper and electronically held data. So what do I mean by paper data? Well, even if you write somebody's details on a post-it note, if it's for your business, then you need to be compliant with this legislation. Then after we had the Data Protection Act 1998 come in, all of a sudden we had the internet turn up with all its little quirks and foibles, and so therefore the legislation needed updating. So the EU Commission came to our Information Commissioner, the authority on this in the UK, and said, well, we need something that now brings it all more up to date. So they took all the same concepts but brought in the EU General Data Protection Regulation, or GDPR as it's very friendly known. But that's 3,000 pages long, and our ICO went, well, that's fine for you in Europe, but I'm very sorry, we're only going to implement 1,000 pages of it. So we have our own version in the UK. So we now have, since the 25th of May 2018, the UK GDPR, the Data Protection Act 2018, and the e-privacy regulations were carried forward from before. So that's the bit that does websites and emails. But we don't tend to use the term generally GDPR in the UK because that tends to mean the EU version, and that doesn't apply under UK law. What actually does this legislation apply to, though? Well, it applies to personal information used in a business context. So that's any information that relates directly or indirectly to a natural person. Okay. Under the 98 Act, we had living individuals. Well, living individuals then have got some problems with cats and dogs and parrots and monkeys and God knows what else. So they've made it to a natural person. Interestingly, there is no definition of natural person in the legislation, so I guess that's up to us to decide. Within that definition, and this will apply to those of you that particularly work in the therapy sectors, of special category data, where you might collect information on your clients about their health, physical, mental, or physical or mental health or condition. Also, race we have to take into account, and ethnicity. And so therefore, and in fact, actually, the fact that we're all on this call today is personal data about each of us. What the legislation provides is a framework for organisations to demonstrate compliance and that they've thought about looking after people's data. Size of organisation doesn't matter. It doesn't matter if you're a one-man band or whether you employ 250 people. You have to abide by this legislation. That's also true of public or private sector. So it doesn't matter if you're working in the NHS or whether you're me sitting here in my front room, you are still processing personal data and subject to this legislation. So the Information Commissioner's Office, as I said, is called the Competent Supervisory Authority. They have produced reams and reams and reams of guidance on how we're supposed to do this, how we're supposed to take the concepts that are in the law and put them into practice. This is not a law that says, thou shalt do this, thou shalt do that. This is a law that says, you should do this if you do this with information. Okay, so that's what we're looking at. So we have a situation where we have, this bit is in the UK only, we have the UK data protection fees regulations. Sue, can you mute yourself, please? Thank you. And this is where we have the ICO registration in place. Now, if you process data electronically, even if it's just email addresses and keeping contact information, you are still processing data electronically in your business. Therefore, you must be registered with the Information Commissioner's Office, which you can do through their website. It's not something I can do for you, but I can talk you through the process if you want me to. Most of us have 10 or less employees, therefore we fit into the Tier 1 category, which currently stands at £40 a year or £35 a year if you pay by direct debit. Direct debit is the easiest option. It just comes round and they just let you know that it's coming up for renewal and going to come through, and then it just rolls over. So what does this give you? Well, this protects you from a £400 fine for starters. If you are found to be processing data electronically and you don't have one of these in place, then you could be fined a starting fine of £400. So you need to balance up whether it's worth paying £35 to £40 a year to avoid that £400 fine, in effect. Everything else that we need to put in place is actually right across the board. So Roberta, you need to pin back your ears, darling. This is coming for you too. The main piece of thing to have in place is called a privacy notice. Now, it used to be called a privacy policy or a privacy statement, but they decided that both of those terms were too official, too legal. People were switching off from them. People are more likely to take notice of a notice. This needs to be short, as concise as we can make it, whilst containing certain elements as dictated by the ICO. This is your contact information. What you do about third parties, sharing of data. Now, you cannot run a business in the UK without sharing data. It's not feasible, can't do it. We're sharing data here today. So that would all go in the privacy notice. Now, something else that goes in the privacy notice is what you do about cookies if you've got a website. Now, don't know how much any of you guys know about cookies. These ones are fat-free and calorie-free. They are little computer pieces of code that allow us to actually see each other even today. This is using cookies for us to be shown on the screen, for example. We don't have to have a separate cookie policy or separate cookie notice. We can just put a paragraph into the privacy notice. Okay, so that's the kind of thing that we can do. We can put these We only have to make sure we've got the concepts covered and that the information's there. No legal language. So as Rosemary said, the solicitors are sending out a lot of stuff about this, and a lot of it is written in legal language. That immediately becomes illegal and against the guidance because it has to be easily understood. The next thing we have to do is then take these privacy notices and take them a step further. So you have to have one regardless of whether or not you have a website, okay? You still have to have a privacy notice for your business. If you are using emails, if you have forms on your website, if you use forms generally to collect information, even on paper, they need to have a privacy notice on there. As individuals, we have the right to ask for a copy of any of our data that is held by any organisation in the UK. My favourite one to do for people is HMRC. I have a lot of fun with HMRC. But there's no reason why you can't ask your bank or your council or the school if you have kids for a copy of the data that's held on them and or you. So you could be giving out copies of forms, etc. So you have to show on the form that you have taken into account people's personal data and their compliance with this legislation. It's a very short piece of text that's required, but it's very easy to get wrong. If you put too much detail into any of these things, then you could be breaking the law. There is a very fine balance as to how much information we put in to protect your business, but also to make sure that you are being compliant and transparent about what you're doing. This is also true of the accountability document. Now, the accountability document was new with GDPR, and you just keep it in your business. This is not outward-facing, public-facing information. Again, we have guidance from the ICO as to what we should include. The shortest I can get a privacy notice or an accountability document is 1.5 pages of A4. But that's a lot shorter than a lot of the ones I've seen on the internet. I've just done one for a client where their original version was 19 pages long. And even I lost the will to live after page 2. So yeah, it's, and as you can tell, I get quite excited by this stuff. I know I'm very weird. But yeah, it needs to be kept short, and that's why it needs to be kept short, so that people don't lose interest and they can find out how you're using their data when they want to. So that's generally the things we need to put in place. So what else can we look out for? What things can we do with this, and how do we go about it? Because we need to make sure we're protecting people's data as we do our businesses. So several things that come up when we do this. The big one at the moment is artificial intelligence. That is huge. Lots of problems with artificial intelligence. There are already a lot of legal cases going on with this stuff. I'm not saying don't use it. I personally don't use it. And I'll tell you why in a minute. But as long as you follow some general rules, you'll be fine. The problem with artificial intelligence is people are getting the artificial intelligence tool to just produce a piece of text for them, and then they're just lifting that piece of text and using it as is. This can get you into all sorts of trouble with copyright, intellectual property, and also privacy legislation. For example, I am a member of Lions International, so I do a lot of charity work, and I do data protection for them. They have a guy in America has just built an AI tool for us to use for marketing purposes. What we can do is take the information out of our database, copy and paste it straight into the AI tool, and it will produce a press release for us or a Facebook page prompt for us. And that's fine because we've put the information into it. When he was testing it, he tried it out on 100 pieces of information about lions. 96 of the results came back, broke the law. That's 96 out of 100 broke the law. International law, US law, European law. So it's really, you've got to be very, very careful if you just use the text that AI gives you. Takes away a lot of creative thinking as well. Back in the days, I am a linguist student, and back in the days when I was learning Russian, we had Google Translator came out, which was an early version of AI. And they put into it to do the UK phrase out of sight, out of mind into Russian. Put it into Russian, translated it back from the Russian into English, and the result was invisible idiot. Now, again, I know of people using AI to do translations. Be very careful, because often words can have more than one meaning in different languages. And you could end up really calling somebody an invisible idiot, no matter how incidentally that might be. Another thing that comes up often is, well, how can I do email marketing? Well, yes, you can do email marketing. There's nothing wrong with doing email marketing in business, especially if you are doing it to people you know. So there's no problem with Rosemary putting out something like, for example, this chat we're having today on the internet. No problem at all with any of that. It's going out to people that we know because it's gone out to the Facebook group. And therefore, they're all going to just get the information they need. Sharing my data was not a problem. You all need to know who I am before you come along. Oh, I'm not listening to that idiot again, for example. If you do not know the people that you're marketing to because you've got a list, then you need to make sure you've got text in that email that allows people to know where you got their data from, why you're contacting them, and give them the opportunity to turn around and say, no, thank you, I don't want the information anymore. You must always, when you are putting something out, give people the opportunity to withdraw their consent if they want to. Always, always, always. That is a golden rule, okay? Even with people you know. They have the opportunity to withdraw consent at any opportunity. We all do. We can withdraw consent under most circumstances. So there may be circumstances where you cannot withdraw consent. There may be circumstances where actually the organisation is justified in using that data. So at the beginning of this, Rosemary and I were talking about taking photographs or videos at the network meetings, the face-to-face ones, and then uploading those onto Facebook, into the group. No problem with that. That's why we're there. We're there to be seen. We're there to talk with other people and discover what other people do. If we were to, if you don't want to appear in those photographs or videos, then when you know the photograph is about to be taken, just say, hang on a second, and remove yourself from the camera shot. I hate having my photo taken, and I certainly hate being videoed, but this is what we have to do in terms to promote our businesses. People buy from people. You need to see the people to be able to buy from them. So there's no problem with sharing data in those circumstances. If we were to go around the room in that kind of scenario and ask every single person, is it okay if I take your photograph? Is it okay if I take your photograph? Not only does that get extremely irritating when you go to group after group after group, especially if you are a regular attendee at that particular group, not only does it get extremely irritating, actually, it's illegal. Wow. How about that then? Because you are forcing people's consent. If you are forcing people's consent, that makes that consent illegal and completely worthless. So just something else to bear in mind. So this is the same as sharing data. There is no reason why you cannot share data. What you must do is keep data safe and secure. You must take all reasonable, feasible, and practical steps to do so. So whether you have you work off your laptop like I do and you have it password protected, whether you do things where you might have, so for example, on the Lions, we have a public facing part of the website, but we have a members area. That members area is password protected. So only the members can go in there and see the information that's in there. It's a way of looking after people's data and keeping it secure. If you're doing email marketing and you're sending out a general email to a lot of people, it's worthy to consider using BCC, blind carbon copy. Then they won't all see each other's email addresses, because you don't know if every one of those copy addressees knows the email address of all of the others. So therefore, if you use BCC, you are protecting each and every one's personal information. An email address, when used in a business context, is personal data covered by this legislation. Data retention is also part of this. When GDPR first came out in 2018, I had a client come to me and says, "Have I got to delete my database?" No. Why do you think you've got to delete your database? Oh, well, because somebody else I met networking said he was going home to delete his 30,000 people's worth of data off his system. No. You have every right to use that information. You've collated that information in your business. It is your client database. It is your contact database where you might need to get in contact with somebody to do something, to help you out with something. You have every right to hold on to that data as long as you have a need for it. That's the key. There are no data retention periods stated in the legislation. And this is because we have data that falls into different data sets in a business. So we have anything that's related to the accounts comes under tax law. And we have to keep that for 6 years plus the current year, because that's what the tax law says. Okay. If you are working in HR and you have an employee, then that's different. You keep their data. I think it's until after 3 years after they leave. I think it is, because they have that 3 years after you've left somewhere to take out a grievance. So therefore, they have to keep their data until that 3 years is up. Okay. So there are all sorts of different rules that are not data protection that we have to just take into account. Photographs at school was another classic. Oh, data protection says that the school can't take the photo. Doesn't say any such thing. Doesn't say any such thing at all. Safeguarding laws say that there may be an issue if you take a picture of a class in a school. That's not data protection, that's safeguarding. Different set of rules, different set of laws. People tend to use data protection because they think they can use it as an easy excuse not to let you do something. Rosemary will tell you, I never say, no, you can't do that. I say, well, hang on a second, let's look at it from a different angle and maybe change the approach. Yeah? So it's a positive way of saying, well, I really wouldn't do it like that, but, you know, this way will stop you getting yourselves into any trouble. One of the things we can do is we now have access to any data that's held by anybody around the world. We have the right to know how they're processing our data. Under this legislation, we have the right to know how they're processing our data, what they're doing with it, how they're keeping it secure, and make sure they're not doing anything with it that they shouldn't be doing with it. Now, this might seem to be quite simple, and it's actually very easy to do, and it doesn't cost you a penny. Okay, if you make the request, it doesn't cost you a penny, because they're not allowed to charge anymore under the legislation. But it equally applies to you and your business. Anybody that you have had dealings with can send you a subject access request, a request to see the data that you hold about them and about them only. If you have children at school, providing they are under 16, you can ask for a copy of their data. Once they're over 16, you cannot ask for a copy of their data. Only they can ask for a copy of their data from the school. Schools, by law, secondary schools especially by law, have to keep your child's data until that child reaches the age of 25. And that's everything that's ever been written about them while they've been at school. So employers can go and ask about that information, but you and your child is entitled to a copy of it, but no data can be erased from a child's record. No data at all. So one of the things that this brought in was the so-called right to be forgotten. It's not a right to be forgotten, it's a right to ask to be forgotten. If the holder of the data has a reason, legal or otherwise, which is justifiable to hold on to the data, then it doesn't get deleted. Okay, that's an important note to take care of. Yes, I have made requests on HMRC. They're great fun. They have a month to go and find out 200 places around the country. Woo! That's their problem, not yours. So if you are thinking that you want to make a request on somebody for a copy of your data, then get in touch, especially now. Well, I would leave it a couple of weeks because we've got Easter coming up. They're not allowed to take that out of the 1 month. They're not allowed to take weekends out of the 1 month. And this year, Easter's late. So if we did it just before Easter, we'd have the first May bank holiday in there as well. Woohoo! So we can really mess with them. I had a client once and all he wanted to do was mess with HMRC and tie them in knots. Fantastic. So this, you can see, is extremely powerful stuff. But if you've got everything in place, appropriately written in the first place, then you're covered. I can help you to do that. I can help you to look at what you've got or put the stuff in place for you. Rosemary will tell you I do not charge thousands and thousands of pounds to do this. But I'm happy to give you advice, to help out and to check something through with you. If I think your privacy notice meets all the requirements of the ICO, then I will not recommend changing anything. I do not change anything for change's sake. But if you've got a privacy notice that's 19 pages long, then I'm afraid we need to do something. All right? So have I got any questions?
Yeah, I've got a question, if that's okay.
Of course it is.
Okay. I just wanted you to sorry, just getting it up. So I write about the types of personal information I collect. I currently collect and process the following information, and that's name, contact details, blah blah blah, email address.
Okay.
But at the end, I take all reasonable steps to keep your data safe. I store personal and sensitive data in secure storage sources, paper or electronic. Does that cover enough? I mean, that's not my whole policy, but in regards to storage of data.
It doesn't matter. You don't actually need that much detail. By having that much detail in there, you're actually causing yourself problems.
Okay. As a therapist.
Because if you put in that kind of notice, I collect name, address, email. Yeah?
Yeah.
And then you go away and collect a phone number and it's not listed in that policy, you're collecting that information and using it illegally.
Okay.
So we don't put anything like that in there.
Okay.
Right? By putting in how you keep data secure, that is a flag to a hacker to say, oh, I wonder how she's doing it. I better go and have a look at this.
Okay, so not to write how you keep the data safe.
No.
Okay. And
so there's all sorts of different ways we can do it. I mean, if you want to send it to me, Catherine, I can send it back with notes on it about why we wouldn't put this in and why we wouldn't put that in.
Oh, lovely. Thank you.
So I'm quite happy to do that because, like I said, I'd have a look at stuff for you and go through it. And then I don't charge until I actually start doing work for you. So, you know, we start going through from there.
Can I ask, is in terms of GDPR, what the expectation is for the storage of the data then?
You keep it as long as is necessary and as long as it's kept secure.
So
That's all it says.
as long as necessary and as long as it's kept secure. So it could, for example, if I have a waiver form, then that's got a name on that I need to keep in case I need to send that off. It's got no personal information, but it has, well, beyond a name and a disk wave, but I can store that on my computer.
When you start on your computer, what
Yeah.
we need to do is have on that form. So presumably then you get them to sign it.
Yes.
Yeah, so that's personal data. So you've got 2 pieces of personal data there for already that I haven't even seen the form, and you've got their name and you've got their signature.
Mm.
Okay, so it's still personal data, still captured by the legislation.
Okay.
Okay, now if you were, for example, I'm trying to think how I can put this. You also may have sensitive data there because you may have somebody's race or ethnicity available by their name.
Yep.
Okay, so what we would do is we would put a very short piece of text on the bottom of the form in case they ever request it. But also, when they've signed it, they've seen it.
Mm.
So
Okay.
you then have their consent to use it because they've signed it.
Okay.
You
This
don't
is
need to ask
actually,
for their consent.
yeah, this is actually less complicated than what I thought then. It's not so against you, is it? It's no,
The
it's
whole
quite
thing is
straightforward.
designed, the whole thing has been written in conceptually so that we can use it and fit it into our businesses. Yeah. And this is my speciality. I'm not legally trained. When I learnt this stuff in the Foreign Office, I learnt how to implement it. How do we make this work in practice?
Okay.
Yeah, does that make sense?
Yeah,
So
thank you.
I know when you look at it and you think, oh God, this is really scary. That's where I come in, because we break it down back to being the same, to make it really practical to put in place. Because if we make it practical for people to put in place and everybody can understand it, not just you, but anybody that you come into contact with can understand it, what it means is that then we have met the criteria. And it's if you understand it, it's far less scary. It's just breaking it down into what we actually need to do and having things written in an appropriate way. Like I was saying with your privacy notice, if you put too much information in there, you can actually create legal loopholes for yourself that other people could exploit. So we don't do that. And also, if we make it quite nice and general that it just meets the requirements of the ICO, then because we've got the basic information in there, then we don't have to keep changing it. We don't have to worry about going and having a look. Oh, have I covered this? Have I covered that? No. Rosemary, how long ago is it I wrote yours? You know?
Oh, I don't know. When we first started, I guess.
Yeah.
Yeah.
Yeah. And we just don't need to change anything. We don't need to go in and have a look at stuff and things like that. So I hope that's helped. We had another question on the chat I saw come up. Kirsty, yeah, exactly. When you've been on the receiving end of an HMRC data request when I worked there, a bit intense as the time gets down to the people that are dealing with it, time is ticking. Yep, it's only a month. I once had to do 200 MPs subject access requests, 60 of which came in on the same day, and we still only had a month. And I had to go worldwide and get information because I was working in the Foreign Office. Time doesn't change. They've still only got a month. So it can get very intense because that time is ticking and you have to respond within that time. So I tend to get people to just let me know if they get that kind of request, and let's work on it and see if we can get it done. How to create safe business terms and conditions. Right, okay. Terms and conditions. I don't do terms and conditions per se, so I don't write the main terms and conditions. What I will do is have a look at them and make sure you've got a data protection bit in there. Again, all we need in there is how you're dealing with data in very general terms, where your responsibility ends. Okay? So your responsibility ends with data outside of your control. So if you can't control the data, then that is then done. That is handed over then to another data controller. So you can work with data controllers. You can each be a data controller, i.e. the legal entity responsible for the data. But we need to make sure lines are drawn so that if somebody does make a complaint, nobody can pass it back on to you. Do bits like that into terms and conditions, or I might do it in a contract. But your main piece of privacy notice is going to be your main privacy notice. That's going to be your main thing that explains how you as a business process the data. If you are a sole trader, everything about your business is personal data because it links back to you. Does that help? It's Eugenie that's put in the question. Have I helped? Oh, I hope so. I can't see people. Good, fantastic. Thank you for that. Cool. And again, if you want me to have a look at a set of terms and conditions, I'm happy to do so. So I can put perhaps Rosemary, we can put my details in the, when you post this, we can put my details into it and then people can get in contact with me. Any more questions? Well, hopefully I've demystified this stuff for you. That's my main purpose.
Now, Robyn, if somebody hasn't got anything in place, what's the best way to start?
Depends how long you've been in business. When you start off, you've got about 6 months to get this stuff sorted out and in place. So you need the registration with the ICO, and you need a privacy notice, bare minimum.
And can someone write their privacy notice themselves? Are there examples online? Could they get an example online and maybe ask you to check it or something like that?
Right, I wouldn't recommend it. We have to do something called privacy by design. Privacy by design says you take your business as a standalone, completely away from anybody else doing the same kind of thing, and write your own privacy documentation. So look at your business in its own bubble. This means that you can't use templates, despite the fact they are on the Information Commissioner's Office website. Their own guidance says don't use templates, and then they're providing templates. Their templates actually are incredibly complicated. Even I don't understand their templates, and I've been working in this stuff for 25 years. Even I don't get it. So I wouldn't recommend it. I wouldn't recommend going and find somebody else's and, oh, I like the look of that, copy and paste that into my own, because again, you can't prove privacy by design. So the best way to do it is actually, if you are worried about it and you're not sure about it, if you want to have a go at writing your own, I've got no problem with that. If you want me to have a look at it, I've got no problem with that. If you want me to do it for you, then that's fine. That's part of the package I offer, where I do all the necessary bits with your privacy notice and your cookie audit, and so your cookies are included and all that kind of stuff. So we have a chat, and then so a bit like I did with you, Rosemary, back in the day. Just have a chat about what you do, how you do it, and then I can take it on there. And everything I write, if you use the wording I use, because again, there's no wording for any of this in the legislation. If you use the wording I suggest, you're covered by my professional indemnity insurance.
So just give us an idea then. So if someone's got a new business, just wants to get this done, what's their investment to just hand it over to Robyn, roughly?
Right, so your investment to hand it over to Robyn is £180 nil VAT.
So £180, no VAT?
No VAT.
Right, okay, fantastic, thank you.
That doesn't include the £35–40 to the Information Commissioner, because I can't do anything about that.
Lovely. So for the £180, you'll write the privacy policy,
you get the privacy notice, you get your short ones for your emails and your forms, you get an accountability document, you get a subject access request procedure to start with, and then it really depends if there's anything else I need to include.
Lovely. And if anyone's thinking about that, one thing I'll say for Robyn is she's always in your court. anytime I've needed help from Robyn, I've just emailed her and she's got straight back to me. So if anything happens and you've got a challenge, believe me, this woman is absolutely rock solid. And when GDPR first came in, we were at a networking meeting and Robyn happened to be they were talking about GDPR and Robyn happened to be sitting next to me, and she'd done my compliance, but obviously not for this. And the guy said, has anyone got a data protection expert? And she nudged me and said, go on. And I said, what do you mean? And she said, me. And it's because we'd worked together about probably 8 or 9 years before. She was still in my court. Yeah, she would still have my back. You're kind of her client forever. So your £180 will go a very, very, very long way. So yeah.
The only time I would charge after that is if I'm doing something specific for you that takes me some time to do it. If it's just answering a question, takes me about 10 minutes, then I'm not going to charge you for it, because that takes more time for me to work out how much to charge you than actually just answer the question.
Lovely. Okay, good. Okay, is everyone complete? Thank you all for coming. Just shout if you've got any more questions. I'll put Robyn's, I'll send this out. Actually, should we just say what, I'm just going to message just tell me your email address, Robyn.
Robyn, ROBYN.
I'll put it in the chat, folks. Yeah.
At Adavista, AD for Delta, AV for Victor, IST for Tango, A.com.
There you go, folks. That's in the chat.
That's it. That's me.
Amazing. Wonderful. Good. Thank you so much.
You're very welcome.
I think we'll just revisit this in about a year. It's a good thing to do for everyone, isn't it?
Yeah, because you never know when people have then come on board, or people have then gone, oh, yeah, I remember I was supposed to do something about that. So, yeah.
Yeah, and it's given me, even someone who works with you, it's given me a couple of reminders today about different security things that I can tighten up on, and just to check things. But sometimes I think if you use a different email server, maybe flip from MailChimp to MailerLite or something, these things don't get transferred. And then you've got to go back and check up on them. So in that case, I'd probably send an email to Robyn and say, does this look okay? And she'd just tell me where I've got to fit it all in. So brilliant. Okay. Lovely. Thank you all so much. Thank you, Robyn.
You're very welcome. Take care, everybody. And I hope to hear from some of you soon.
Excellent. Lovely. Thank you.